a patent and trademark law firm. We help inventors, business owners, startups with exploring patent protection, trademark protection, and IP, also offering copyrights now, and trade secret analysis. And the topic for today is how to protect your invention before filing your application. So we're going to get to that in just a few minutes. We are attorneys, right? Matt, you're still barred?
I am still licensed.
Excellent. As am I. So we're not your attorneys. We'd like to be. And if we have any clients on, hey, we are your attorneys, but let's not talk about anything confidential today. But there's this part that I got a question from one of our folks that just did a consult with Michael. Say, hey, look, I haven't filed yet. I've done some activity. I've done these things. Am I protected, right? What do I do? Maybe if I've disclosed it, or if I've, got a teammate or a co-inventor. And I think it's a really good topic.
I think that, from my perspective, just working with trademark clients who have patent questions, I feel like the disclosure, the 1 year disclosure bar, that puts a lot of clients up.
Yes, it does.
A lot of folks don't know that the clock is running once they invent something.
Well, right. Well, the clock starts when you publicly disclose, right? And so this 1 year clock, which is it's unique. The US and a bunch of other countries have this grace period, and it's up to 1 whole year. Let's say you just shout from the mountaintops, you publish all over online, you write a book about your invention today, you can actually still file on February 7th, 2025. And you'll be timely. You'll be your patent, if it becomes granted, will not be invalidated because of that 1 year earlier disclosure. But if it's 1 day after, right, on the 8th of February, 2025, that patent, even if you're able to get it granted, could be invalidated because of that earlier disclosure. The whole concept of this is that we want to incentivize inventors to file, right? Share the knowledge, get the information out, have it filed, the examiners look at it, you get your reward, but we all become smarter. Thank you very much, Mr. and Mrs. Inventor. And that's the idea of the patent system. The disincentive, we don't want to incentivize, you try to make money on your invention before you file. So there's a 1 year period is short enough time where I think it's fair to say, hey, who knows with some of these software startups, but your profitability, you're able to get revenue is limited in just that 1 year. So there are two things that can start that clock. I mentioned public disclosure, and there's a whole host of things that, what does that mean? And we're going to get into that. The other one is what's called on sale. If you put it on sale, offer it for sale, then you have started your timer. And so those are the two biggies to know about. If you've got something that you might want to protect, that you got a hint that, hey, maybe this is really something unique and big, and I might want to protect it. Even if you're not telling everyone about what it is, if you're selling the product, selling what you hope to get a patent on, that'll still start the clock.
I probably have the wrong information here, obviously, but so if I invent something, can I register it as a patent 10 years from now if I don't tell anyone about it?
You can. You take the risk that no one else invents it first.
Oh, interesting. See, I didn't know that. I thought that once you invented something, you had to go file within a year, but that is not true. That is a lie.
True. Well, it's just not true. There are lots of certainly large companies that have big R&D groups, and they invent all day, every day. That's their job. And it's the decision of probably in-house IP counsel to say, okay, which inventions do we file? Do we move forward with? And which ones do we kind of keep in an incubator? There's no, hey, you invented this 20 years ago. It's just a matter of, is it worth the money? Is it the right time in the market? And how much risk do you want to take that someone else files it before you do?
That's an interesting concept. Is it the right time to file, right? Because you might have a product that is incredible, but it is not timely. There's no need for it right now, right? Absolutely. But 10 years from now, all of a sudden there's a need for it, and then you can get your whole 20 years potentially.
Yeah, kind of a cost benefit. Sometimes there's that idea of, hey, let's just get it filed, even though we're not planning to go to market with it, just to prevent someone else from getting a patent on it, right? It's called a disclosure, sort of a defensive disclosure. So let's talk about this first prong, which is, okay, what qualifies as a public disclosure? And first of all, it is public. So anytime you're sharing it with a third party online, where someone in your field would be able to find it. Okay. So if you're talking to like your mom, at the kitchen table, one-on-one, there's a lot of argument to say that's not a public disclosure, because that information, unless it's broadcasted, right, you're sharing on live media or on air, there's really no way that someone else could find that and be able to and have knowledge of it.
Makes sense.
If you write a book about it, or if it goes out into a news article, a periodical, okay, now you're headed toward disclosure. The more typical example is, hey, I took it to a trade show, right? This is sort of the example. And if you've showed it off to the public at a trade show, yeah, that counts as a public disclosure.
What about a non-disclosure agreement? What if I take it to another company who might be interested in purchasing it and I have them sign an NDA before I disclose?
Boom. If all parties are under a contract of non-disclosure, it does not start the timer. Okay. But don't forget that on sale bar, we'll talk about that soon. This was a big case that came down 2 or 3 years ago, pharmaceutical company. They had everything under wraps with an NDA, but because they made and signed a deal with the manufacturer of the pharmaceutical, that counted as an offer for sale.
Really? Even though it wasn't to consumers, it was a sale of the invention to.
Yes, sale of the invention. They're making revenue, right? The pharmaceutical company, the would-be patent owner, was making money more than a year before filing, and that's exactly what the patent system is set up to not allow.
Interesting.
Yeah. So, beautiful point about the NDA. So, confidentiality agreements, binding contracts between individuals and companies count, as long as the parties are all accounted for, right? And you're not, signing it with one person, but sharing it all over. As long as you've got, written contracts between everyone, that will not start the timer. So the nuance for like the trade show, back to the trade show. So I've showed up my invention, even given out maybe giving out samples would be bad. Let's say you're just showing it off, okay? Presenting on it. And you did that 2 years ago. And now you want to try to patent it. We can ask the question, well, whatever you showed is not going to be able to be claimed in your invention. But is there something else right behind the scenes that you kept confidential that was not shown or described? You could still protect that. So sometimes a disappointing discussion, but there can still be something to move forward with to try to have some proprietary, technology moving forward. So yeah, that's the big thing, how to protect your invention before filing. I would say if you have a co-inventor, that's another situation where you want to probably have something in writing. You want to have a contract about who invented what aspects of the invention that will come into play when you get ready to file. As you get through patent prosecution, sometimes claims will get rejected or amended. And it could be, whether it's the fault of the attorney or the examiner, now your claim set is really only limited to one inventor. Okay, so it's important to know who invented what parts of the invention. There's going to be any money put in, right? You're investing money, just like any business deal. You want to put down what the expectations are, what your return on investment is going to be on that business venture. So perhaps forming a company to separate your personal liability would be a good idea as well. This could all happen before. And sometimes, this last thing I wanted to mention on this topic is we'll do an initial consult and the invention is still very much in the idea phase, right? And it hasn't fully formed. There's still yet to really convince themselves that it performs and does the things they want. They haven't built a prototype yet, and they haven't really figured it all out. So what you have to do, and sometimes, is find a co-inventor, find someone else, an engineer or a designer, to help you finalize the invention. So of course, confidentiality agreements are huge there, making sure you work as locally as possible to be able to enforce any type of breach of contract. Out of state is not quite as good, and of course, out of country is the biggest risk when you're going and working with someone else pre-filing. And then the last note is, if you're going to be sharing it before filing, even under confidentiality agreement, keep a careful list, a ledger of who you've talked to, names and dates of when you disclosed it. If they turn out to be a bad actor, you'll have clear documentation in terms of who disclosed what to who. There are situations where an inventor will share something, and then that person or someone who was listening heard about it, even though they signed a confidentiality agreement, will defraud the patent office and try to beat them to the patent office and file it as if it were their invention. And there is a remedy as the inventor to go back and get that ownership back in your name if you can prove that they derived it from you. It's called a derivation proceeding. So we covered a lot, but those are some things to think about pre-filing on the patent side. Any tips from you on the pre-trademark filing?
Yeah, file, I mean, early and often. I mean, we on the trademark side deal with bad actors too. Actually at Bold IP, we're representing a couple clients right now who have former business partners who have filed trademarks at the USPTO that aren't theirs, and now we're having to claw them back. And so you can prevent all that, and prevent paying us as attorneys a lot more money if you file the trademark early. So early and often, get the points on the board, get the application out there. You can hold a trademark application at the USPTO for up to 36 months after it's approved. So
there you go.
You don't have to go to market. So I mean, theoretically, what that means today is that you have darn near 50 months to go to market if you apply for an intent to use trademark today. So there's really no excuse to there's really no excuse not to file before you go to market with a product or a service.